correct to say that the floor test can only be directed to be ordered by the governor before a ministry formation and not after. In fact, your lordship's words used in Bumai and Shivraj were, it is the duty of the governor to hold a floor test. The only constitutionally ordained forum is the Assembly of Parliament, and no governor or individual in his own opinion can form a view whether a majority has been won or lost, and the only way forward is a floor test. And the court frowned upon the tendency because there used to be a huge misuse of Article 356 to dismiss governments and dissolve houses. So the courts frowned upon it and said that the first instance, the governor must call for the floor test in such matters. Now, my lords, what happens in this case? In this case, on the 27th, and in my earlier submission before your lordships on Navam Revia, I had even then said that I'm not for a minute suggesting that when we filed our 32, Nabam was not one of our cases. That's not our contention at all. Nabam was one of our important arguments. The other was equally important, was violation of principles of natural justice. And the third was imminent, immediate danger to the lives of the MLAs whose houses were being burned and relatives being threatened. That is why we came in a 32. And that is hugely different and was not barred by Quixote at all. Because our contention was not that your lordship decides on the disqualification petitions, as they are claiming. That was not the prayer in our petition. Our contention was that Nabam, even as it stands today, has held the judicial field. It is a constitution bench decision, and the speaker had no jurisdiction to proceed with the matter at all, apart from the principles of natural justice being violated. The court, keeping all this in mind, only on the issue of natural justice on that day, extended the time, did not injunct the speaker, extended the time. Now, extension is interpreted to say because extension was granted till 12th of July, it effectively meant an injunction. I don't see how. If you violate a provision of the rules which says adequate notice should be given, the speaker doesn't give that notice, the Honorable Court says gives them more time. Now, after that, my lords, what does the governor do? The governor in his letter writes to say that 7 independent MLAs who were supporting a ministry have withdrawn support. The leader of the opposition has written to me to say that they have no confidence in the ministry. Within the ministry, a large section of the legislative party have moved a resolution saying that they do not support the MVA ministry and government. Given these facts, I think it prudent and call upon the then Chief Minister, Mr. Thackeray, to come and prove his majority on the floor of the House. Lords, I put a question to myself, what else is the speaker, the governor expected to do? Your lordship's words again in Bumai are, by whatever process or means. The words used by your lordships in Bumai are, by whatever process or means, the governor can gather the information that is required, which raises a credible doubt as to the majority of a government in power. The only course open is a floor test. And that is what the governor goes ahead. You refuse to face that floor test. And your only answer to that is, it was a fait accompli. So, my lords, if democracies which have to be tested on the floor of the House are going to be decided on, it's my fait accompli, so I won't go and face a floor test, and yet want to continue in government, is that acceptable? Is that constitutionally acceptable? The only mechanism known is a floor test, and you evade that. And then you cast aspersions on a constitutional authority to say, which in any case today is the norm, you can cast any aspersion on anyone you want to. And you say that the governor in question failed to discharge his duties, acted with bias in a malafide manner. Because what was he expected to do? 7 independent MLAs say we have lost confidence. The leader of the opposition writes, 34 of the 55 MLAs pass a resolution saying we have no faith in the ministry any longer. Now, before I proceed further, my lords, I want and before I proceed, issue-wise, I want to show these two judgments. Because so much time has been spent on the powers of the governor and that he acted with malafide intent, and the solutions that your lordships asked for, what could have been done by the governor, it is said he definitely could not have asked for a floor test. And the only way to get out of all these judgments is to say that those cases did not involve a disqualification petition pending. Now, my lords, the moment your lordships in Shivraj Singh Chauhan, Kuldeep Bishnoi, and any number of judgments have said that, and Shivraj Singh Chauhan especially, that proceedings under the 10th schedule, which concern disqualification and a trust vote, operate in entirely different fields. In the meantime, the right of an MLA to participate in the proceedings of the House continues, and he continues to participate and vote. Now, my lords, if their submission is taken to be correct, firstly, it's wrong because it's in the teeth of what Bumai and Shivraj Singh Chauhan says. Then when your lordships ask them what could be done, they say zero definitely if disqualification petitions are pending, which is in the teeth again of Shivraj Singh Chauhan, which says that irrespective of disqualification pending, irrespective of resignation letters pending, they will participate in the House. And that comes back to the same question that if an MLA is permitted to participate in the floor of the House, the legality as far as those proceedings are concerned can't be questioned. You can't say that all proceedings, budgets, decisions, bills passed will all be annulled and we will restore status quo ante. And when I come to Rana, I'll point out to my lords, Rana is completely misread. Rana was in the context where the Speaker's power, the Supreme Court held that when the Speaker decides a disqualification issue, he sees the events as on that date. Because there, a set of MLAs had gone and shown support to a rival faction and gone to the governor. The split took place later. They sought to seek the defense of the 10th schedule as it then existed. The Supreme Court ultimately said no. As far as the governor is concerned, the facts will be seen on the day. When they approached the governor, the Supreme Court never said that the MLAs who participated in trust votes, the MLAs who've taken decisions, proceedings which have been legally conducted, will all stand annulled. Because ultimately it comes down to the argument being that if ultimately your lordships were to hold them to be disqualified, the EC proceedings couldn't have gone on, the trust vote could not have happened, and thus restoration of status quo ante, which would mean annulling everything that has happened. That's effectively the argument being made before your lordships. To stay the EC proceedings, 4 hours of arguments were addressed that EC should not go on with the same argument. That if EC goes ahead with it and later on it's found that these people are disqualified, they have no right to approach the EC. And a question was put by our lordships even on that day, what about his right as a member of a political party? In any case, who will decide this? Whether there has been a split in the political party, and then you presume, as if I have argued that there is only a split in the legislature party and not in the political party. We have consistently said so, including in our resolution dated 21st of June 2022, that a legislature party is integral and organically connected and co-joined to a political party. What is said in the legislature party is a reflection of what is happening amongst millions and thousands of cadres of the Shiv Sena across the country, because there was a huge discontent of aligning in the MVA with people who you were ideologically opposed to right through your political careers and existence. That was where the discontent arose from. That you fought an election with another party, after that suddenly we went along with another party. That was the political discontent. So we were conscious and rightly talked about the political party discontent. But who will determine this? Who is the whip? There are 2 whips we are talking about. They say your whip is only appointed by the legislature party. We say no. To say that our whip appointed by the legislature party does not represent the authority of the political party is wrong. Ultimately, right or wrong, the EC today has taken a decision. That's the subject matter of another petition which your lordships will decide. But even on that day when a stay was asked for, our respectful submission was, how can the Supreme Court today, without the concerned constitutional authority at all deciding on the issue, take a call on these matters? Just because you say so and you presume we are per se disqualified. Now, please have, my lords, Bumai and Shivraj Singh Chauhan only on the powers of the governor before I proceed, because that's one of the most glaring submissions made in the teeth of settled law of the land. Please, for the judgment.
So your submission starts with the primary principle that proceedings under the 10th schedule operate independent of the power of the governor. Irrespective of the pendency of the 10th schedule proceedings, at any point of time, the governor can ask a floor test.
And
number one. And if he asks, then are there any limitations with respect to the fact that the 10th schedule proceedings are pending? Should he wait, not wait? Because the primary question will depend upon.
Yes, I bow down. My lords, I bow down. Your lordships have summed it up very well. May I just add to what your lordships are saying? In addition to what your lordships summarized, is my second limb of the argument that your lordships have already held in any number of judgments that an MLA during pendency of a disqualification petition is fully entitled to participate and vote. If that were so, then what is the hindrance to a floor test being conducted? And in all those matters, the issue arose the same. During pendency of disqualification petition, should the floor test take place or not? I'll show those paras. And your lordships answered by saying, why should the floor test not take place? In the meantime, you can't, without the decision of the speaker, say that a person is disqualified. So
there's a little catch there. You see, there's a catch there.
The problem really is this, that the antecedent circumstances which give rise to the necessity of a floor test are based on an alleged defection.
Right.
So, why is a floor test necessary? The need for a floor test arises because of the fact that a group of legislators may be disqualified as a result of their having formed a split from the party. This may or may
not from, but
yes. Yeah.
Within there's a rival
the legislature party. Now, if the validity or the legitimacy of the split is itself in question, then holding or directing the holding of a floor test before the disqualification issue is resolved would result in this. That are you not then putting a premium on the very circumstances which gave rise to the disqualification?
So my lords, your lordships have answered that. And I'll show those judgments where this very question arose. That can those MLAs against whom a disqualification petition is pending participate in a floor test?
There also you are right.
Look at the reverse.
Because the law is very well settled that the mere pendency of a disqualification petition does not preclude a member of parliament or the legislature in the state from exercising all rights and performing all functions of a legislator. Undoubtedly. But equally, we have to be cognizant of a situation where the reason why he or she can exercise all the functions as a legislator is because the speaker has been not permitted to decide the disqualification issue.
May I, with respect, say, my lords, as far as that
so
is
step one, the speaker is told to defer a decision on the disqualification issue. So the disqualification issue cannot be decided. Therefore, why can the legislator not be restrained from exercising all rights on the floor of the House? Because of the judicial edict that you shall not hear the disqualification until the 12th of July, step one. Step two, why is the trust vote required to be held? Up to the 21st June, there was never any requirement of a trust vote. What is the requirement of a trust vote? The requirement of a trust vote arises because these 7 independent MLAs, then the 34, they all start clamoring and they say, well, there is disquiet within. We don't owe allegiance, and our chief minister has lost the confidence of the party. Now, the point of the matter is this: that if that is the reason for the unsettling of the government in the House, then the antecedent basis of that is itself the allegation of disqualification. So if you allow a government to be toppled then, in
May I,
circumstances
with respect,
like this,
say, firstly, and I
Yes.
said I've just begun.
This
There
is
is
not
no
a case.
timelines.
You're just flagging it.
Yes,
You're just
yes.
flagging it.
yeah, we are just flagging it.
No, I am very grateful. I'm very grateful. Yes.
Right? These are the concerns.
Yes, yes.
This is not a case where, say, there is a 3-party or 4-party coalition in a state. 2 parties say we are pulling the rug. They're entitled to, there's no disqualification. You have 4 parties which have come together in an agadi, and those 2 parties say we are pulling the rug and we want to get out of this government. It doesn't have the mandate of why we came together. Governor can simply say, the 2 of your constituents have, pulled out. Now, please show me that you established, you have the allegiance of the House. Because there is no, the problem arises in cases like this, where the reason for the trust vote is so intrinsically related to the alleged disqualification itself. You're right. My judgment in Shivraj says that, well, these are 2 independent issues. But there is
No, let me.
also an intrinsic
So,
connection.
my lords, let me.
Call one another thing. In addition to this, what are their submissions? There is no difficulty that both are independent. Correct? There is no difficulty that both can go together simultaneously. But their submission is correct that if those persons who are to be against whom the disqualification proceedings are pending are permitted to cast their votes on the protest in the no confidence motion. If ultimately after some time, correct, the speaker takes a decision and they are disqualified from day one, from the date of their conduct, correct, then what will happen to that? So their case is that it is better, correct, that the disqualification proceedings are initiated first. That is what their submission. You have to answer that also.
Yes, my lords, I will.
That is the crux of that main submissions.
May I? Let's firstly.
You can argue on this was only warm up.
Yes,
Let's start with Bomai. Because
Yes,
Bomai
I thought let me start with that and I'll come. I'm conscious what my lord has said. I'm very grateful. I'll address those questions.
anything more than 5 in that sense is gospel for us, because we are bound by
Absolutely.
Not only that, my lords, of course, your lordships are
ultimate
right
test.
there, but even I want to show 2 paras, even as far as Bumai is concerned, on how Shivraj deals with it. It's important for your lordships to see that.
Fair enough. So we'll see Bomai and then
Yes, first please see Bumai and then see.
Overarching principle.
Yes, yes. Judgment. Judgment, volume 2. Kindly have para 119.
where is it? Convenience compilation?
Volume 2, my lords.
All right.
Judgment compilation, volume 2, PDF page 368. PDF page, I think.
Or PDF page
PDF page 368.
358.
368.
This is great dismissal.
No need.
119.
Savant.
Who gets the
My lords, may I?
Yes.
Absolutely. But in this connection, it is necessary to stress that in all cases where the support of the ministry is claimed to have been withdrawn by some legislators, the proper course for testing the strength of the ministry is holding the test on the floor of the House. That alone is the constitutionally ordained forum for seeking openly and objectively the claims and counterclaims in that behalf. The assessment of the strength of the ministry is not a matter of private opinion of any individual, be he the governor or the president. It is capable of being demonstrated and ascertained publicly in the House. Hence, when such demonstration is possible, it is not open to bypass it and instead depend on the subjective satisfaction of the governor or the president. Such private assessment is an anathema to the democratic principle, apart from being open to serious objections or personal malafidés. It is possible that on some rare occasions, the floor test may be impossible, although it is difficult to envisage such a situation. Even assuming that there arises one, it should be obligatory on the governor in such circumstances to state in writing the reasons for not holding the floor test. The High Court was therefore wrong in holding that the floor test was neither compulsory nor obligatory, or that it was not a prerequisite to sending the report to the president recommending action under 356(1). Since we have already referred to the recommendations of the Thackeray Commission in this connection, it is not necessary to repeat them here. Now kindly have para 121, same page. We may, on this subject, refer to the unanimous report of the 5-member Committee of Governors, which recommended as follows. The test of confidence in the ministry should normally be left to a vote in the Assembly. Where the governor is satisfied by whatever process or means that the ministry no longer enjoys majority support, he should ask the Chief Minister to face the Assembly and prove his majority within the shortest possible time. If the Chief Minister shirks this primary responsibility and fails to comply, the governor would be in duty bound to initiate steps to form an alternative ministry. A Chief Minister's refusal to test his strength on the floor of the Assembly can well be interpreted as prima facie proof of his no longer enjoying the confidence of the legislature. If then an alternative ministry can be formed, which in the governor's view is able to command the majority in the Assembly, he must dismiss the ministry in power and install the alternative ministry in office. On the other hand, if no such ministry is possible, the governor will be left with no alternative but to make a report to the president under Article 356. Now kindly have para 391 on PDF page. PDF page 517. 391. 395. Yes. My lords have para 390.
Yes.
We must also say that the observations under point 7 is equally misplaced. It is true that action under Article 356 is taken on the basis of satisfaction of the Union Council of Ministers, but on that score, it cannot be said that legal malafidés of the governor is irrelevant. When the article speaks of the satisfaction being formed on the basis of the governor's report, the legal malafidés, if any, of the governor cannot be said to be irrelevant. The governor's report may not be conclusive, but its relevance is undeniable. Action under 356 can be based only and exclusively upon such report. Governor is a very high constitutional functionary. He is supposed to act fairly and honestly consistent with his oath. He is actually reporting against his own government. It is for this reason that the Article 356 places such implicit faith in his report. If, however, in a given case, his report is vitiated by legal malafidés, it is bound to vitiate the president's action as well. Regarding the other points made in the judgment of the High Court, we must say that the High Court went wrong in law in approving and upholding the governor's report in the action of the president under Article 356. The governor's report is vitiated by more than one assumption totally unsustainable in law. Constitution does not create an obligation that the political party forming the ministry should necessarily have a majority in the legislature. Minority governments are not unknown. What is necessary is that the government should enjoy the confidence of the House. This aspect does not appear to have been kept in mind by the governor. Secondly, and more importantly, whether the Council of Ministers has lost the confidence of the House is not a matter to be determined by the governor or, for that matter, anywhere else except the floor of the House. The principle of democracy underlying our Constitution necessarily means that any such question should be decided on the floor of the House. The House is the place where democracy is in action. It is not for the governor to determine the said question on his own or on his own verification. This is not a matter within his subjective satisfaction. It is an objective fact capable of being established on the floor of the House. It is gratifying to note that Shri Raman, the former President of India, has affirmed this view in his Rajaji Memorial Lecture. And now kindly have para 395 on page 518. To read 393. 395. The High Court, in our opinion, erred in holding that the floor test is not obligatory. If only one keeps in mind the democratic principle underlying the Constitution and the fact that it is legislative assembly that represents the will of the people and not the governor, the position would be clear beyond any doubt. In this case, it may be remembered that the Council of Ministers not only decided on April 20th, 1989 to convene the Assembly on 27th of that very month, that is within 7 days, but also offered to prepone the Assembly if the governor so desired. It pains us to note that the governor did not choose to act upon the said offer. Indeed, it was his duty to summon the Assembly and call upon the Chief Minister to establish that he enjoyed the confidence of the House. Not only did he not do it, but when the Council of Ministers offered to do the same, he demurred and chose instead to submit the report to the President. In the circumstances, it cannot be said that the governor's report contained or was based upon relevant material. There could be no question of the governor making an assessment of his own. The loss of confidence of the House was an objective fact, which could have been demonstrated one way or the other on the floor of the House. In our opinion, wherever a doubt arises whether the Council of Ministers has lost the confidence of the House, the only way of testing it is on the floor of the House, except in an extraordinary situation where, because of all pervasive violence, the governor comes to the conclusion and records the same in his report that for reasons mentioned by him, a free vote is not possible in the House. Now kindly have, my lords, Shivraj Chauhan, which follows this.
Para 396 also there.
Yes, my lord. I just give me a minute. Just
397 also.
396. We make it clear that what we have said above is confined to a situation where the incumbent chief minister is alleged to have lost the majority support or the confidence of the House. It is not relevant to a situation arising after a general election where the governor has to invite leader of the party commanding the majority of the single largest group to form the government. We need express no opinion regarding such a situation.
Now see para 397.
Yes. We are equally of the opinion that the High Court was in error in holding that enactment addition of 10th schedule to the Constitution has not made any difference. The very object of the 10th schedule is to prevent and discourage floor crossing and defection, which at one time had assumed alarming personal predilections. A legislator elected on the ticket of a party is bound to support that party in case of a division or vote of confidence in the House, unless he is prepared to forego his membership of the House. The 10th schedule was designed precisely to counteract horse trading. Except in the case of a split, a legislature has to support his party willy-nilly. This is the difference between the position obtained prior to and after the 10th schedule. Prior to the said amendment, a legislature could shift his loyalty from one party to the other and any number of times without imperiling his membership of the House. It was if he had a property in the office.
So here they say, actually,
Yeah.
Bomai deals with a completely different situation. Bomai was a case where the Council of Ministers had offered to summon the House, the session of the Legislative Assembly within a period of 1 week. Governor says, so sorry, I'm convinced that you have lost the confidence of the House. Therefore, you send the report to the President under Article 356. There the court holds that this course was not open to the governor. The only way to establish whether they had lost the majority of the assembly was to order a floor test. And therefore, the governor couldn't, on his own personal opinion that they had lost the majority, say that, well, I'm going to send a report to the president under 356.
So,
Second, they also make it clear that with the introduction of the 10th schedule, unless it's a case of a split, which was a position prior to the deletion of the split in 2004, the only case where you can not vote for your own party is a split. Otherwise, you're bound by the foretails of the party which is
no
brought into
difficulty.
power.
No difficulty.
So now, post 2004, with the split having gone away as a defense,
Yes.
the only other available exception is a case of a merger.
Right.
Save and except in the case of a merger, you are bound to vote for the party.
Right. No difficulty. But my lord, there's two things. Firstly, no doubt, as the facts, my lord, the Chief Justice summed up of Bommai. But Bommai doesn't just restrict itself to those facts. What Bommai says is the moment a support to a ministry is withdrawn, the fact is that in that case, the Chief Minister was keen to face a floor test. The governor dissolved the House and sent a report to the President. But what para 119 says is the moment a support to a ministry is withdrawn, the only option left to the governor is to conduct a floor test.
You know, if we accept this extreme proposition, very radical results will result. On the one hand, you have the 10th schedule, which is to prevent, the constitutional sin of defections. On the one hand, you say that, well, somebody who defects or causes a split is liable to a disqualification. At the same time, we say that, look, even if that person is liable to be disqualified, in the meantime, you must hold a trust vote on the floor of the House. That is why, if the antecedent reason for a floor test is based on a violation of the prescription in the 10th schedule, then holding a floor test at that stage will defeat the whole basis and purpose of the 10th schedule then.
No, my lords, may I with respect say, when your lodges firstly...
And you are legitimizing then a defection which is otherwise not permissible under the 10th schedule. That's what is happening actually.
Firstly, our case is not a case of a split at all. I am not relying on any defense at all. I am neither relying on 3, which in any case does not exist, or on merger. That's not been my case. I've right through argued that we are talking about a rival faction within the party, which is dissent and a sense of democracy within a party, and we claim that we are the Shiv Sena. And that is what comes to be decided. I'm not for a minute either relying on the defense or merger or on the split of 1/3. That's their contention. My case has never been.
But whether you are the Shiv Sena or not, can't be decided on the floor of the...
Will be decided. Of course not. Your lordships are right. Who is the political party will be decided by the Election Commission of India. And that power is vested in the ECI. And your lordships, in judgment after judgment from Sadiq Ali downward, that said that the exclusive jurisdiction, and there's a presumption of validity as far as decisions of the ECI are concerned. I come to those decisions.
On the 30th of June, there was no decision of the ECI.
No, my lords. On 30th, there was no decision of the ECI for the simple reason that if the decision will come when someone raises that issue, it will only be when a party approaches the ECI. There can't be a decision of the ECI devotes a party approaching the ECI.
Mr. Kaul,
the ECI...
No, where is the question of the party approaching the ECI? For our understanding, on 30th, there was only one party. You were part of the party?
Yes.
There was a faction within or without. You contested the election on the strength of a ticket given by the party, which was the original party. Then,
and I still say I'm the original party. They are the overwhelming minority.
To say you are, as we understand, to show it within the party. On
yes,
the basis
and absolutely right. My lady is right.
Do it in the House.
No. I'm not saying I do it in the House. That's why I'm saying floor test and majority in a political party are completely different issues.
When you go back to the party members to say, okay, here is a faction that we think are actually the Shiv Sena. So we are going to the party as if not just the organization, but each one who counts in the party, that makes the party to say, now we are.
So let me answer that. One is, which is the rival faction within the party who should be recognized as the party under the symbols order. That's what the symbol order provides for. That can only be decided by the Election Commission and no one else, who represents the party and is the recognized, which faction is the recognized political party. That's one part. In the meantime, a ministry which has lost the confidence of the House cannot continue is a completely different issue for which the floor test is meant. I'm not going for a floor test in this matter to show that I'm the majority in the Shiv Sena political party. That has never been my case. Has never been my case at all. I'm going to the floor of the House to show that you, Mr. Thackeray, and the NVA government, coalition government that you lead has lost the majority because 7 independent MLAs and 34 of the 55 MLAs have no faith in you. Now they are presuming that this is only a rival faction within the legislature party and not a rival faction within the political party. Whereas your lodges have time and again said you can't segregate the two. A legislature party is also an extension of the political party. In fact, for the continued recognition of a political party, the legislative presence of its MLAs and the percentage of vote it polls is a necessary ingredient for continuing recognition. Under 6A and 6B of the symbols order, and Sadiq Ali took note of it, they said for a party's continued recognition as a political party, its performance in the electoral hustings, its vote percentage, its MLAs and MPs are equally important. These are their arguments. And that is what I've been saying. You yourself, you're the judge, you're the jury, you say, per se disqualified, there was a split only in the legislature party, and thus nothing else needs to be done. My whole case has been, it's a case of internal dissent. We are the faction which represents the Shiv Sena. That issue can only be decided by the election commission, where your lodges refused to stay those proceedings. The same argument was made. As far as the floor test is concerned, it is only restricted to the issue whether the chief minister or the ministry has the confidence of the House or not. And what does the governor do? The governor says, comes and face a floor test and you resign. Now, that was a pertinent question that day, which was put by your lodges and my lord, the Chief Justice, saying that had this chief minister not resigned, one could have possibly seen what is the effect of those 39 plus 4 votes or 3 votes. Now, 2 answers to that. You remove those 39 plus 3 or 4, 42 votes. We are still through by a mile. And I prepared those charts and I'll show. You remove each of those 39 plus 3 votes, whose 42 in all, whose disqualification was pending, we were still through. In that case, that's one. Secondly, my lords, my first contention would still be, why should those 42 be deleted at all? Because let's face it, on that day, Nabam held the field. If Nabam held the field, Nabam said that as far as the speaker is concerned, he should not proceed with his with disqualification till its own case is decided. But let's take it. Let's take it, they should have been excluded. A chief minister who does not go through even with the deletion of 39 plus 3 or 39 plus 4, both for the election of the speaker and the election of the chief minister. He fails in both cases. I prepared those charts with 42, without 42. Because as your lodges rightly said, with those 42 votes, then the total strength also comes down. It can't be that you remove them and you don't remove them from the strength of the House. So whichever way you look at it, presuming for a minute, the trust was directly related, according to me, no. Manoj, in every disqualification is only a 10th schedule case. There can either be a 191-1 or a 192-2. These are only 2 cases of disqualification. One can either be for the grounds provided in 191-1 or 192-2 is 10th schedule. In 191-1, there's a procedure provided for the president, speaker, etc. In consultation with the election commission, you get disqualified. Under 191-2, when it comes to that, that's where the 10th schedule is kicked in. Now, all those judgments that your lodges have dealt with are all cases that if a disqualification is pending, the trust vote will still go through. In each of those cases, it could have been argued that if this disqualification petition had been decided, the trust vote would have been differently affected. It could have been the same argument in every case.
Bombay lays down a normative principle that floor test is the actual test.
Yes.
It hasn't really taken into account the sequence in which the power of the governor has to be exercised in the case of defections. Bombay, therefore, it goes only that far. In its application, in the subsequent judgment of Shivraj Singh Chauhan, has the court given an exposition of how Bombay operates
Yes.
in the context of Shivraj Singh Chauhan?
So should I go to that, Manoj? Because I
asking you
halted.
that question.
Yes, I wanted to. I wanted
it?
to actually go to.
Because it just flags it here in
Yes.
Bomayan 396 and 397. And it says that the situation that would arise so far as the principle of Bommai is concerned in the context of 10th schedule stands on a slightly different footing. It says that far and then doesn't say anything further. The thing which needs to be seen with the advent of the 10th schedule is that power of the governor to ask for a floor test in the context of 10th schedule when it should be exercised. Because the fundamental difference is the floor test will be determined by this decision because the composition of the house will change.
Your Lordship, absolutely.
For which you have your answer is that it makes no difference on facts. And we are more on the principle.
Yes, no, Lordships are absolutely right. Even on the principle, my lords, when your Lordship said that a floor test must go on in other judgments, leave aside our case, must go on irrespective of the pendency of disqualification petitions, that was not in vacuum. Your Lordship said it in the context that mere pendency of a disqualification petition cannot impact a trust vote being conducted. That's what your Lordship said. Because in every case where a MLA is disqualified, his vote one way or the other, whether his abstention or actual voting, would have had an impact on the trust vote. So my question is, my lord, to myself, how and in what ways? The individual facts of every case will vary on what day the letter went, what happened. But the principle, as your lordship rightly said, is that you cannot merely, because a disqualification petition is pending, prevent an MLA from voting in a trust vote. Now to say that you had the trust vote done because in the meantime your disqualification petition was pending, these are all hypothetical questions. Now then questioning the governor to say governor should not have called a floor test, what else could the governor have done, my lords?
Okay, sure, Shivraj Singh.
Yes, Shivraj Singh Chauhan. Please have. Sorry?
Judgment Compilation Volume 1.
Yes. Judgment Compilation Volume 1,
360.
PDF 1360. Please, one.
I know.
My lord. Yes, my lord, please start with paragraph
Which volume? Which volume? Sorry.
1359.
Huh?
Judgment Compilation 1.
One.
And page 13.
1359, para 16.
Yes. Everyone.
Mr. Maninder Singh, learned senior counsel.
Just one second.
नहीं लिख लेना लिख लेना यार
What is the citation?
Yes. Mr. Maninder Singh, learned senior
One
counsel
minute.
appearing.
Yes.
Mr. Maninder Singh, learned senior counsel appeared in an application for impediment moved on behalf of 16 members who had tendered their resignation to the Speaker, but whose resignations have not been accepted. On their behalf, Mr. Singh submitted that an elected member of a legislative assembly has an absolute right to resign by virtue of provisions of Article 190 of the Constitution. The Speaker of the Madhya Pradesh Legislative Assembly accepted the resignations tendered by 6 members who are part of the same group of 22 members within the span of 1 day, and in doing so has chosen not to make any inquiry in regard to the remaining 16 letters of resignation. Resignations and disqualifications are distinct concepts. The exercise of judicial review in regard to advice tendered by the Governor to the Chief Minister to convene a trust vote is not warranted. 16.5, in urging submission, Mr. Singh placed reliance on the decision of 3-judge bench in Srimant Bala Sahib versus Karnataka Legislative Assembly. Then 17, Dr. Abhishek Manu Singhvi, learned senior counsel appearing on behalf of the Speaker of the Madhya Pradesh Legislative Assembly, submitted that, and kindly have 17.8, my lords. The precedents of this court in regard to convening of a trust vote have arisen in the context of fresh elections held to the legislature and not in the context of a running assembly. This was the same contention raised there. Now kindly have para 60, 65 and 66.
You are right, same contention.
65 and 66. PDF page 1380.
383.
1380, my lord. Para 65. My lord, the Chief Justice has para
Yes.
65. In analyzing the observations made by the 9-judge bench in S.R. Bommai, it is pertinent to remember that the governor in that case did not call for a floor test. Rather, the governor of Karnataka sent a report to the president based on which the proclamation was issued under Article 356. The observation in S.R. Bommai can be relied on in determining whether the governor possesses the power to call for a floor test. Discerning the subsequent question of when the exercise of such power is appropriate is a distinct issue. On a perusal of the above observations in S.R. Bommai, it is evident that whether or not the Council of Ministers has lost the confidence of the House must be determined only on the floor of the House and not by the governor conducting an independent verification. Where the governor has reasons to believe that the incumbent government does not possess the support of the majority in the Legislative Assembly, the correct course of action would be for the governor to call upon the Chief Minister to face the Assembly and to establish the majority of the incumbent government within the shortest possible time. An exception to the invariable rule of testing whether the government has the Assembly's confidence on the floor of the House is envisaged only in extraordinary situations where, because of existence of all-pervasive violence, a free vote is not possible in the House. Then 66. As a matter of constitutional law, it would not be correct to proceed on the basis that constitutional authority entrusted to the governor to require the Council of Ministers to prove their majority on the floor of the House can only be exercised at the very first inception after general elections are held, and not when the governor has objective reasons to believe that the incumbent government does not command the confidence of the House. The governor is not denuded of the power to order a floor test, where on the basis of the material available to the governor, it becomes evident that the issue as to whether the government commands the confidence of the House requires to be assessed on the basis of a floor test. Undoubtedly, the purpose of entrusting such a function to the governor is not to destabilize an existing government. When the satisfaction on the basis of which governor has ordered a floor test is called into question, the decision of the governor is not immune from judicial review. The court would be justified in scrutinizing whether the governor prima facie had relevant and germane material to order a floor test to be conducted. It must be noted that the governor does not decide whether the incumbent government commands the confidence of the House. The purpose of holding a floor test in the Legislative Assembly is precisely to enable the elected representatives to determine whether the Council of Ministers commands the confidence of the House that verification is not conducted by the governor. The decision in S.R. Bommai, in fact, held that recourse to the power under 356 was not warranted in a situation where the issue of confidence could yet be decided on the floor of the House by calling for a trust vote. Undoubtedly, in that case, it was the Chief Minister who had suggested, following a meeting of the Cabinet, that the House should be convened for the purpose of testing the majority of the Council of Ministers. The significance of the decision lies in the fact that the decision of the Governor to submit a report under 356 was faulted on the ground that the floor test would have been an appropriate course of action. Now, so whether in Bommai, the Chief Minister offered to face a floor test and the Governor declined to do so, maybe the peculiar facts, the larger principle in Bommai or in Shivraj Singh Chauhan that your lordships have laid down, that your lordships have 66 though.
The first half of 66 exposition is that it's untrammeled to that extent.
Please, my lords.
The first half of 66, para 66 is governor's power is untrammeled, not confined to the inception.
Right. And that was the specific question posed.
See, para 71,
Very good.
Come further.
Yes. Yes.
power of the governor.
Yes. 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 The powers which are entrusted to constitutional functionaries are not beyond the pale of judicial review. Where the exercise of the discretion by the governor to call a floor test is challenged before the court, it is not immune from judicial review. The court is entitled to determine whether in calling for the floor test, the governor did so on the basis of objective material and reasons which were relevant and germane to the exercise of the power. The exercise of such power is not intended to destabilize or displace a democratically elected government accountable to the Legislative Assembly and collectively responsible to it. The exercise of the power to call for a trust vote must be guided by the overarching consideration that the formation of satisfaction by the governor is not based on extraneous considerations. So, my lords, please read this with the observations in Bommai that no independent view of any person, including the governor, at the end of the day, he must take recourse to a floor test because these are not his individual opinions. His individual opinions are only meant that prima facie it appears that the majority has been lost by the ministry in power. And after that, how does he determine it? The court says you can't determine it on your own and say you've lost majority, thus I'm dissolving the House. The best way to do it is ask the Chief Minister concerned to face the floor test. And that Chief Minister in this matter refuses to face the floor test and resigns before that. And the only argument being made is because it could have been an empty formality and disqualification petitions are pending. Firstly, my lords, that can be no argument in law, but B, I go a step further, you exclude those 42. What happens? You still lose.
Para 72 also.
72.
72 and 73.
72 and 73, my lords?
Yes.
Yeah.
72 and 73. While the Constitution recognizes that the governor does not possess a power I'm so sorry. While the Constitution recognizes that the governor does possess a power inhering in the office to monitor that the elected government continues to possess the confidence of the Legislative Assembly, this entrustment ought not to override or displace the basic responsibility of the executive to the legislature or the ability of the legislature to demand accountability of the executive arm of the state. Dr. Singhvi's submission that the governor cannot demand a trust vote except at the initial constitution of the Legislative Assembly following an election would be to unduly constrain the constitutional entrustment authority to the governor. Undoubtedly, the largest number of precedents emanating from this court have dealt with the situations where a trust vote was called at the time of the initial formation of the government following an election. One of the reasons for this may well be the prevalence of disputes at the time of the initial formation of the government in the states. But this line of precedent would not exhaust the power of the governor, nor does it suggest that the authority which is entrusted to the governor cannot be exercised once a government has been formed. Mr. So-and-so, on the other hand, accepted that there may be situations where the House is not in session, having been prorogued, and there arise circumstances leading the governor to a reasonable belief that the government has ceased to command a majority in the Legislative Assembly. This, in our view, would certainly be one of the situations where the governor would be justified in calling for a special session in the course of which the incumbent government may be required to establish that it continues to hold the confidence of the House. In a situation where the House has been summoned, following the aid and advice of the Council of Ministers, the position would be more nuanced in the sense that the remedy of a no confidence motion would be available to any segment of the legislature seeking to espouse the view that the government has ceased to command the confidence of the House. In exercising the constitutional authority to demand a trust vote, the governor must do so with circumspection in a manner that ensures the authority of the House to determine the existence or loss of confidence in the government is not undermined. Absent exigent and compelling circumstances, there is no reason for the governor to prevent ordinary legislative process of a no confidence motion from running its due course. The governor is an appointee of the president but does not represent either a political ideology or a political view. The governor is expected to discharge the role of a constitutional statesman. The authority of the governor is not one to be exercised in aid of political dispensation, which considers an elected government of the day to be political opponent. The precise reason underlying the entrustment of the authority to the governor is the ability to stand above political conflicts and with the experience of statesmanship to wield the authority in a manner which subserves and does not detract from the strength and resilience of democratically elected legislatures and the governments in the states who are accountable to them. To act contrary to this mandate would result in the realization of the worst fears of the constitutional framers, who are cognizant that the office of the governor could potentially derail democratically elected governments, but nonetheless place trust in future generations to ensure that the government of the people, by the people, and for the people would not be denuded by those who are designed to act as its sentinels.
Era 74 also, first 4 lines.
In discharging this crucial role, it is necessary that the governor bear in mind that the purpose underlying the entrustment of the authority to require a trust vote is not to displace duly elected governments, but to intervene with caution when the circumstances which are drawn to the attention of the governor indicate a loss of majority. And that is exactly what the governor did in this case. 7 independent MLAs write to him to say we are withdrawing support. The leader of the opposition writes, 34 of the 55 MLAs, now of course 40, say that within the party, that's why I know this whole thing of split, merger, that's never our case, that's their case. To say that since there is no merger, since clause para 3 is not available, you have per se incurred the disqualification. And our case right through has been that whether we represent the political party, the Shiv Sena is the recognized political party, or you do, is a matter which the Election Commission will decide. The Speaker, my lords, if your lordships will recollect, and just
Equally in the present case, when the leader of the opposition writes to the governor could have advised the leader of the opposition bring a motion of no confidence to the House.
right, but my lords, nothing stops the governor. Today, we are testing the bona fides of a decision. My lords, to say that the governor opted for one option
The leader
instead of
the
the
opposition cannot duck the responsibility of summoning or placing a motion of no confidence by getting the governor to direct the convening of a trust.
My lords, may I with respect say the leader of the opposition did not get the governor to do anything. The leader of the opposition brought it to the notice of the governor. 7 independent MLAs also brought it to the notice of the governor. 34 MLAs within the party wrote to the governor to say that we will not support this ministry. And the governor, in exercise of his discretion, after applying his mind, satisfying himself that the conditions accepted, followed Bumai, followed Shivraj Singh Chauhan to say that the best course of action available would be a floor test. Now, if your lordships in a 9 judges and Shivraj Singh Chauhan have said that that is the first course, you must follow that. And if the governor says, I'm following it, the only line of attack is because a disqualification petition is
What is
pending.
the objective material for the governor in this case?
Unless the objective material was the moment, firstly, 7 independent MLAs, the leader of the opposition, and 34 out of the 55 MLAs say you do not enjoy.
Independent MLAs have nothing to do with the strength of the government in the House.
Unless they were part of the government.
There is absolutely no role because that applied when the government was formed.
No, my lords, they continued to support the government. Those 7 were part of they withdrew support to the government, my lords. Those 7 withdrew support to the government.
Were they holding ministerial posts?
I don't. Were they holding ministerial posts?
Two of them.
Two of them were. My lords, they were part of the government. They were part of the, well, let's test it. When your lordships in para 121 of Bomai say that the governor,
Remaining gave letters of support to the government during its formation.
please, my lords.
The remaining, apart from the two who became ministers, did they just check it up later?
There was.
Just check it up. Check it up.
We'll check it up. My lords, please see. MLAs who are part of the government say we are withdrawing support. The leader of the opposition says he has lost support. 34 of the 55 ruling party MLAs say that we represent the real Shiv Sena. We have no faith in this coalition continuing. What is wrong? Have called for a floor test. If he had dissolved the house, if he had called someone else to form the government, dismissed the government, he's not done any of it. He's just said you come and prove your majority on the floor of the house. Their entire argument is that because a disqualification is pending, test that proposition, my lords. According to us, because we passed a resolution, they gave a disqualification notice to us. That's our case. Reverse the proposition. Suppose you want to defeat any bill, any decision on the floor of the house, the easiest thing is give disqualification notices to parties.
Now, in this context, if you see para 75 of Shivraj Singh,
Yes,
see
yes.
why the court there held that there was objective material before the governor. That's the kind of, just see that para 75 and 76 in the present case. So we then get some flavor of what are the circumstances in which the governor can call for a protest. Just see that para 75 and
Yes, my lord. May I, with your lordship's permission, Harry? In the present case, the facts which have come on record indicate that the budget session of the Legislative Assembly had been convened on the aid and advice of the Council of Ministers to commence on from 16/3/2020. The governor was intimated that 22 members owing allegiance to the INC has tendered their resignation to the Speaker of the Assembly. Copies of the resignation letters were forwarded to the governor. At this stage, the validity of these resignations had not been discerned and no decision had been made by the Speaker as to whether the resignations were voluntary or genuine. The Chief Minister subsequently tendered the advice to the governor for the removal of the 6 ministers who were ministers in the state government. On 13/3/2020, the Speaker of the Legislative Assembly issued notices of disqualification. However, on 14/3/2020, resignations of 6 members who were ministers of incumbent government were accepted by the Speaker, acting in exercise of the constitutional authority under the proviso to Article 193B. The Chief Minister, adverting to the turmoil in the state, addressed a communication to the Governor, 13/3/20, stating that the convening of the floor test would be a sure basis for resolving the conundrum. This is a strong indication that the Chief Minister himself was of the opinion that the situation in the state had cast his government's majority in doubt. However, upon the convening of the Legislative Assembly, no floor test was conducted and the House was adjourned till 26/3/2020. These facts form the basis on which the governor advised that a floor test be conducted. Based on the resignation of the 6 ministers of the incumbent government accepted by the Speaker, the purported resignation of 16 more members belonging to the INC, and the refusal of the Chief Minister to conduct a floor test despite the House having been convened on 16/3/2020, the exercise of power by the governor to convene the floor test cannot be regarded as constitutionally improper. Now, my lords, apply to the facts of our case. The governor notes there is violence, they are being attacked. 34 of 55 do not support the ministry. 7 supporting independents have also withdrawn. The leader of the opposition has also written to the same extent. He doesn't dissolve. He doesn't swear in another government in power. He says you come and prove your majority. And your lordships, if have right through said that it's his duty to summon the House and said that no governor or any other individual should form an independent opinion. Manoj and Bomai, your lordships, has said that the moment a governor starts forming in these matters and substituting his opinion to dissolve the House, instead of a floor test being ordered, it would be dangerous for democracy. I'm just testing the proposition of the other side, my lord, because it is being said or not. This material, in my respectful submission, is more than sufficient to meet the test of judicial review, because your lordships are not substituting your view for that of the governor. All that your lordships are seeing is whether the decision-making process was apt, it was not accentuated by mala fides or bias in this matter, or any extraneous consideration was not taken into account. And in the given circumstances, my lords, the governor taking the requisite facts into account, the surrounding circumstances into account, comes to an informed decision that floor test should be conducted. And he orders a floor test. Now, because you feel the floor test would have led to a situation where you were unable to face the majority, then that should be the end of your government. Which government should be allowed to continue which cannot face a floor test, my lords? Irrespective of disqualifications pending or not pending, can any elected representative ever say that I want to continue in the ministry as an elected government without facing a floor test?
Now just look at the governor's letter. Can this even, can this be suitable? I mean, look at para 1 and para 2. What does he say? That convenience compilation number,
I think.
that convenience compilation number. Two.
326.
Volume 2.
PDF 326.
Page 326.
Yes, pura para.
Just let's read that.
Yes, my lords, I'll read the whole thing. I'll read the whole letter.
Dear Shri Uddhavji.
Yes. I'm in receipt of 2 letters dated 28/6/2022, which have been received at the Raj Bhavan, Mumbai. The first letter has been given by 7 independent MLAs stating that you have lost the majority on the floor of the Vidhan Sabha and requesting me to call for a special session of the Maharashtra Legislative Assembly and to direct you to prove your majority on the floor of the House. A similar letter dated so-and-so has been received from the leader of the opposition stating that you have lost the majority in the Maharashtra Legislative Assembly and a floor test for proving your majority in the Vidhan Sabha is urgently required. I'm in receipt of a resolution dated 21/6/2022 signed by 34 members of Shiv Sena Legislative Party stating that there is enormous discontent within the Shiv Sena cadre and the electorate on account of the alliance of the NCP and INC. The resolution clearly indicates that the majority members of Shiv Sena Legislature Party want to exit the alliance with NCP and INC, and to that end, they have reaffirmed the appointment of the leader of the Shiv Sena Legislature Party. I am also in receipt of a letter dated 21/6/2022 addressed by Eknath Shinde to the Deputy Speaker stating that the purported appointment of one Mr. Ajay Chaudhary is illegal, having been made by 16 MLAs without notice and without quorum, and therefore the same is inoperative. A letter dated 25/6/2022 was also received by me, whereby 38 members of the Shiv Sena Legislature Party have alleged that the security provided by the state government to them and their family members have been illegally withdrawn. It is stated in the letter that various leaders of the state government are instigating the cadre to initiate violence against 38 MLAs, as a result of which the offices of some of these MLAs are vandalized. I have also been made aware that there have been grave threat to life of these 38 members and also their families. I have seen the developments through electronic and print media very closely, which substantiate the above facts. The apprehension of the MLAs is also fortified by the letter of the leader of the opposition, who has in fact provided links to videos where Mr. Sanjay Raut has openly stated that dead bodies of the MLAs will come to Mumbai and will be sent for post-mortem. Mr. Sanjay Raut in an interview given to the national TV has also said that ongoing violence is not even a trailer, but is just the warming up. Certain news articles reporting open and rather disturbing threats to 39 MLAs of Shiv Sena have also been enclosed with the letter issued by the leader of the opposition. In response to the aforesaid letter dated 25/6/2022 received by me on behalf of MLAs of the Shiv Sena, I had wide communication dated 25/6/22 directed 1. The Home Secretary, Ministry of Home Affairs, Government of India; 2. The Chief Secretary to the Government of Maharashtra; and 3. The Additional Chief Secretary, Home Department, Government of Maharashtra, Director General of Police, Maharashtra State, and the Commissioner of Police, Mumbai, to provide adequate police protection to the MLAs and their families on the immediate basis. It is thus clear that a majority of Shiv Sena MLAs have given a clear indication on behalf of the Shiv Sena Legislature Party that they intend to exit from the Maharashtra Vikas Agadi government, and that you have been made aware of the same, and that you are trying to win over your MLAs and cadre by means which are not democratic. I am therefore confident that you and your government had lost the trust of the House and the government is in minority. The Honorable Supreme Court of India, in a range of decisions, has time and again held that the governor possesses a power to monitor that the elected government continues to enjoy the confidence of the Legislative Assembly. It is therefore within my power and discretion to call for special session of the Maharashtra Legislative Assembly and direct a floor test to ascertain as to whether you enjoy the confidence of the majority in the House. My discretion is guided by the aforesaid facts. Please refer to Shivraj Singh Chauhan versus Speaker, Madhya Pradesh Legislative Assembly. Further, with a view to obviate any undemocratic method being employed, such as violence, illegitimate and unseemly political bargaining and horse trading in a quest for political power, the Honorable Supreme Court of India has consistently insisted upon convening a trust vote at the earliest date. In the aforesaid case of Shivraj Singh Chauhan, the Honorable Supreme Court has held that a trust vote in the ultimate analysis is to uphold the political accountability of the elected government. Some of the other judgments of the Honorable Supreme Court of India, which require the immediate holding of the poll test are so and so. As per the judgment of Shivraj Singh Chauhan, where the circumstances of violence and coercion exist that would undermine a free and fair vote in the assembly, the governor must take measures to ensure that the sanctity of the trust vote is maintained. In the present case, use of undemocratic means such as violence and coercion to influence the vote cannot be ruled out. The Maharashtra Legislative Assembly rules contemplate voting by a division by asking members to rise in their seats for the purpose of counting the votes. Such procedure for voting would, according to me, ensure that the members are allowed a free and fair vote in the present case. This is in line with the series of judgments delivered by the Honorable Supreme Court. Therefore, in keeping with the constitutional and democratic values and principles, as also the law laid down by Honorable Supreme Court of India and in pursuance of the powers conferred by Article 174, read with 175(2) of the Constitution, I hereby issue the following direction. A special session of the Maharashtra Vidhan Sabha be summoned on 30th 6, 2022 at 11 a.m. with the only agenda of a trust vote against the government. The business of the House shall be conducted in such a way that the speech, if any, are concluded in a short period of time, and the trust vote is concluded on 30th 6 by 5 p.m. The voting will be conducted by members to rise in their seats for the
So
purpose
the
of...
only reason really, a lot of this is completely constitutionally extraneous. The fact that, some MLAs have said that, well, their safety is in peril, that I directed as a governor that their safety should be provided. This has nothing to do on whether the government should be asked to face a trust vote. The only point which he says really is these 2 points. One, 7 MLAs have said that they don't owe allegiance to the government, and more important, the 34 MLAs have indicated that they want Shiv Sena to exit from the alliance
Yes.
with INC and the Maharashtra Vikas
And
Sabha.
not from the party, but from the coalition government. Manos, the resolution of 21/6/2022, as also this letter categorically says that there is a huge discontent within the party.
All what happens is that, once governors start this process of, intervening in a sitting house, that only sort of gives...
Manos, may I with respect say, when you're...
Why not ask whoever wants to move a no confidence motion?
Manos, may I with respect, my lords, your lordships have said...
Why should a government which has been formed and in respect of which there was absolutely no disquiet just a month earlier, be asked to suddenly face a trust vote?
Manos, may I with respect
On the
say...
basis of these...
Manos, for a government to lose a majority, there cannot be a cutoff date. That event in politics can occur at any time. Whether it enjoyed majority a month earlier or it loses majority a month later, with utmost humility I submit, is inconsequential. What is important is on the date when the governor applies his mind, was there a representation by the requisite number of members of the Legislative Assembly to say that we no longer have any faith in this government? Consciously on 21st of June 2022, 34 or 35 MLAs wrote to show that there is a huge discontent and discord within the party of an MVA alliance continuing. They don't say we are merging with someone else or we are splitting. They say within the party, and we do not want this government to continue. 7 independent MLAs who are part of the government, right? Now, my lords, I put a question to myself when from 9 judges to Shivraj Chauhan, your lordships has said the first duty is to summon the House. Why should that governor ask anyone to move a vote of no confidence? When your lordships have guided the governor time and again in various situations to say that the first right you must exercise as a constitutional authority is to summon the House and call for a floor test and ask the Chief Minister to prove his majority. Why should that governor exercise in discretion and say that no, because 1 month earlier there was no disquiet, today a vote of no confidence should be moved and not a floor test? And ultimately, as I respectfully submitted, your lordships are not sitting as a court of appeal. Even if your lordships feel that another course of action may have been a more appropriate course of action, the fact is, as long as what the governor does is within the constitutional principles as laid down in Bhuai and Shivraj Singh Chauhan, that is good enough. Now, for a minute, leave this aside, what fell from my lords, the violence, what was happening to MLAs, exclude that. What is required is the essential ingredient for a floor test. The need for a floor test arises when there is a representation that the concerned Chief Minister of Government has lost the confidence of the House. Now, as far as the confidence of the House is concerned, what material will the government look at? The governor look at? The governor will naturally look at the representations of various MLAs in the assembly to say that they're no longer supporting. What other material can he look at? And that is why, my lords, your lordships.
The head of the political party had not informed the governor that we are withdrawing from the alliance.
No, my lords.
The alliance still continued between the three parties. There was
Yes.
no intimation by the head of the political party.
Who was also the chief minister?
He had not intimated the government.
He had not
that we are
intimated.
withdrawing from this alliance.
My lords, he need not, but if 34 out of 55 write to him to say, my lords, again, as I'm saying, he's not dealing with 10th schedule. That's a separate argument I'll come to. He is dealing with 34 out of the 55 MLAs writing to him to say, we have no faith in this government, in this chief minister. 7 independent MLAs who are part of the government say, we have no faith in this government. Leave aside the leader of the opposition for a minute. Now, my lords, when a governor takes a decision to conduct a floor test, what is the most important consideration in his mind? The most important
Mr. Kaul,
consideration in his
Mr. Kaul, read para 78 of the judgment.
my lords of
Shivraj Singh Chauhan.
just give me a minute.
Apropos what you are saying.
78. The idea underlying the trust, my lord, the Chief Justice has that.
Yeah.
The idea underlying the trust vote in the ultimate analysis is to uphold the political accountability of the elected government to the state legislature. Assertion of accountability is a mirror image of the collective responsibility of the government to the legislature. The requirement of the trust vote fulfills that purpose in the present case. The present controversy has shone a light on the often fluid allegiances of democratically elected representatives. This is a matter for their conscience, and the court expresses no opinion on the matter. However, it is important to note that in directing a trust vote, the governor does not favor a particular political party. It is inevitable that the specific timing of a trust vote may tilt the balance towards the party possessing a majority at the time of the trust vote is directed. All political parties are equally at risk of losing the support of their elected legislators, just as the legislators are at the risk of losing the vote of the electorate. This is how the system of parliamentary governance operates, and the learned senior counsel on both the sides of the disputes congenially admitted that the outcome of the trust vote is the ultimate litmus test for the legitimacy to govern. However, we note that where the evidence indicates that circumstances of violence and coercion exist, that would undermine a free and fair vote in the assembly. The governor and the court must take measures to ensure that the sanctity of the trust vote is maintained. In the circumstances as they have emerged in the case, the exercise of authority by the governor, who was based on circumstances which were legitimate to the purpose of ensuring that the norm of collective responsibility is duly preserved, there existed no extraordinary circumstance for the governor to determine that a trust vote was not appropriate course of action on 16/3/2020. Now, my lords, all that I am respectfully submitting today is that merely because it will turn in favor of one or the other, your lordships deal with those issues. I put myself in the governor's position. My lord, suppose he had not held a trust vote. One of the first challenges would have been, despite a 9-judges bench, despite Shivraj Singh Chauhan, despite MLAs writing to him, why did he not hold the floor test? Where is the requirement in law, my lord, that if a governor, after due application of mind, comes to a conclusion that a trust vote ought to be held, he should nonetheless have a vote of confidence moved on the floor of the House and not go in for a floor test? Where is that requirement in law? And presuming for a minute both options are available and he opts for one instead of the other, would that be enough for your lordships, an exercise of your lordships' extraordinary jurisdiction to strike down the decision of the governor in a matter like this, that this is a decision so influenced by extraneous consideration or so biased or unfair, accentuated by malafide, that we will strike it down as a decision? It's a decision based on due representations made by MLAs.
Yes.
And naturally, my lord, when these MLAs make representations, these are on political considerations.
Mr. Kaul, as your claim is not either a split or a merger, your
Yes.
claim is on the ground that you are the political party.
Right.
Now, in the information given to the governor, to what extent the information available as to you have garnered the political
Yes. So, my lord,
majority, political, not the legislative majority.
my lord,
Where is that kind of a material?
I'll just come to it, my lords.
Yes.
I'll come to
Okay,
it
take your own
tomorrow if your lordships permit.
I'm
Because
just
I'm very grateful. I'm very grateful that your
That's
lordships have
actually,
indicated. Yes.
in so far as the governor's decision is concerned, go by Bommai. the principle of the judicial review is confined to the question as indicated there, and material is available to him, relevant material, then judicial review is available. The relevant material available for him to direct a floor test must be in relation to that kind of a decision that you have now garnered the political, not the legislative, but political power with respect to the party.
May I with
That material is available or not?
I'll address your lordship tomorrow on
No,
that.
in your own time.
10th schedule is where this whole argument of legislature, political party, is political party co-joined with legislature party? Was it only within the political party or within the legislature party is one part. As far as the governor in exercising his powers for a floor test is concerned, his only consideration is whether on the floor of the house, the members enjoy the requisite majority or not. And my respectful submission there to your lordships would be that there all that he has to see is that the elected representatives who constitute the total composition of the house, is there a substantial challenge to say that a large number of them are withdrawing their support to the ministry, which raises a genuine doubt in his mind to say that the majority of the ministry must be proved on the floor of the house, and which material was here. He doesn't have to embark on that exercise, which is a part of 10th schedule, political party, legislature party. All that he has to see is elected representatives, 34 of 55, 7 independent who are supporting, and as I said, exclude the leader of the opposition completely.
But Mr. Kaul, once the government is formed,
Yes.
it is not open to any group of members of parliament or of the legislative assembly to say that, look, we don't want to go with this alliance. You have an alliance of. It is not open to, say, a group of persons who owe allegiance to the dominant political party in the alliance, as in this case, the Shiv Sena was. Right? Shiv Sena had 55 as opposed to 44 of the Congress and 53 of the NCP. It's not open to any one segment of the any political party, whether it was the Shiv Sena or the NCP or the Congress, to say, we don't want to go along with this. That will ipso facto attract the disqualification provisions. You are bound by the whip, and you are bound to vote with your party so long as you are a legislator, unless there is a merger.
That's why, my lords, as I say,
On the one hand, none of them, either 15 or 20 or 25 or 30, can say to the governor that, look, we don't want to go along with the alliance. Answer is very simple. You don't want to go along with the alliance? Vote your leader out in the political party or take a decision in the political party outside. So long as you are a member of the house, you are bound by the discipline of the house. You have to vote with your political party.
so just to answer what my lord,
What they were essentially telling the governor was this: we don't want our political party to continue with this three-party alliance of the MVA, right? We want to exit from that. Governor takes cognizance of it. Now, what he is essentially taking cognizance of is that there is a breakaway segment of this particular party. In that letter of the governor, one thing which is completely absent is your argument that we are the Shiv Sena. The entire letter is postulated on the fact that there was, out of 55, there are 34 people who want to break away from this alliance. And what is this but not a split?
Well, may I have respect say?
The governor at least was not alive to this argument at all, that, you represented the Shiv Sena.
May I?
Extraneous to the exercise of power.
May I with respect say, that is not something.
The relevant material.
The material before the.
Well, that of course, the governor's council will
Therefore, we are very careful in those two paragraphs to say 22 members had resigned. They didn't defect. They said we quit the assembly. Out of them, 6 resignations were accepted by the speaker. 22 were in the same batch. The speaker went and accepted 6. He kept quiet over the 16. And Dr. Singhvi's argument was that you are trying to prevent the speaker. The floor test essentially is to buck the speaker's decision. So to which we said that, look, they were all 22 selling together. Why did the speaker accept only 6 and leave the 16 intact? That is not a case where they split. They said, we leave the house.
Well, as I said, I haven't
the consequences, vacate the house.
I haven't even come to the legislature party versus political party argument, because where my contention will be, A, there are 2 political whips appointed on the same day. As per us, we are following the mandate of the party. My Lord the Chief Justice put a question to say that suddenly you decide to do what you want. That's not our case. on 21st of June 2022, a political whip was appointed. The question is whether my political whip or their political whip is the actual political whip. Because if my political whip is the whip, then I have not disobeyed any order at all. So when my Lord the Chief Justice said that by just saying that you don't agree with the government, you ex facie, look, we've not done that. Our whip, and that is the question when this argument was raised on that day before your lordship, the lordship said, is this the rival faction? Whose whip was appointed? That's first for the EC to say which was the party, which was the faction, which was the recognized political party within. Because according to us, the faction within the party, which is the recognized faction today, was the faction which represents the political party and had appointed duly the whip. And the whip argument, when I come to, I'll show to your lordship, right through the convention of the Shiv Sena has been that the legislative party with the requisite authority of the political party appoints the whip, communicates it to the speaker. And even when the 10th schedule existed, when para 3 existed, your lordship said that the limited jurisdiction under 10th schedule of the speaker is to only see a prima facie split in the party, not embark on an independent inquiry. As far as the political party is concerned, that's the domain of the election commission. Today, it is being presumed as if I did not have the requisite political whip in my favor, that I did not represent the requisite majority within the party, and thus I have incurred. I've incurred the disqualification under the Act, under the Constitution. And my respectful submission right through has been, says who? Just because you say doesn't mean I'm disqualified. That has to be decided by an appropriate constitutional authority, which in this case, the wrong has decided in my favor in this matter. But be that as it may, you can't presume and say that you have incurred ex facie the disqualification and thus you were not entitled to right. After all, the concerned body has to decide that. According to me, I represent within it the view of the political party. Our resolution also, my lords, when your lordships put a question to me to say that this part that we are the Shiv Sena was not something which gets reflected in the speaker's letter. My lords, that letter, so I'm so sorry. The governor's letter. That very letter of the governor refers to the resolution of 21st June 2022, which I'll read out tomorrow to your lordships, which says there's an overwhelming discontent in the cadres of the party. The party does not want to continue. So it's not as if the governor just dealt with, and this is my argument which I've just presented before your lordships, the governor was cognizant of the fact that the resolution on the basis of which 34 MLAs wrote to him in turn referred to the large discord and discontent within the political party, which was because of continuing with MVA. The cause is not important. The reason is not important. The reason could be anything. There it was corruption and it was MVA. Could be anything. The fact remains is they were discontent. The fact remains is that an overwhelming part of the political party did not want to go along. Now, whether your whip represents the right wing, then my learned friend started going into when was the committee meeting held, what was, those are not the, that is not within the purview of the constitution bench today. That will be decided and is being decided by the EC, that who represents within the party the actual recognized political party. I'll even touch on those 18-7, 27-7, which are not the subject matter of this reference to your lordships.
We'll continue. We'll see the resolution which you said you want.
Yes, I will read, my lords. I'm very, very grateful, my lords. I'll continue to read.
We'll continue tomorrow morning.
सुबह अखबारों को जब आज पलट रहे थे तो कुछ जगह एक खबर दिखी इकोनॉमी वाले पन्ने पर। खबर थी कि लगातार तीसरे हफ्ते भारत का फॉरेन एक्सचेंज रिजर्व कम हुआ। हमने थोड़ा और खोजबीन की तो अंतर्राष्ट्रीय न्यूज़ एजेंसी रॉयटर्स की खबर मिली, जिसकी हेडिंग थी भारत का फॉरेक्स रिजर्व 11 हफ्तों के सबसे कम स्तर पर पहुंचा। तो हमने सोचा क्यों ना आज आपको फॉरेन एक्सचेंज रिजर्व, जिसे फॉरेक्स भी कहते हैं, उसका पूरा तिया पांचा समझा दिया जाए। तो आज की मास्टर क्लास में सी फॉरेक्स रिजर्व पर बात करते हैं। सबसे पहले सवाल कि क्या होता है फॉरेक्स रिजर्व। बात शुरू से शुरू करते हैं। फॉरेक्स रिजर्व होता क्या है? फॉरेक्स फॉरेन और एक्सचेंज दो शब्दों से मिलकर बना है। हिंदी में इसे विदेशी मुद्रा भंडार कहते हैं। नाम से ही क्लियर है, विदेशी मुद्रा का भंडार यानी दूसरे देशों की करेंसी का जो भंडार है उसे ही फॉरेक्स रिजर्व कहते हैं।